Today we want to talk about alternative justice systems, and joining me in studio to talk about alternative justice system, because remember, the only way that most of us have been brought up to know is to go to the courts. But did you know that there's something called alternative justice systems, which means there's some cultural systems that were being used before, and that has now been embedded into our modern way of, resolving conflict, which is always a part of human life. And to talk to us about alternative justice systems is none other than Dr. Steve Akoth. He is the Vice Chair, National Steering Committee on Implementation of Alternative Justice Systems. Welcome to the program, Dr. Steve.
Thank you very much. Happy to be here.
Asante. And also Honorable Rehema Masha, she's the Assistant Deputy Registrar, Alternative Justice Systems. Welcome to the program.
Thank you, Mary. Happy to be here.
Asante sana for coming in. I mean, let's just begin with what alternative justice system is about, and I want to throw that to Dr. Steve Akoth, just to help us understand what is alternative justice systems.
Thank you very much, and indeed, that's a good place to start from. As you rightly put it in your intro, every society, every civilization have their ways of ensuring coexistence, have their way of seeing their world. And long before Kenya became Kenya in the sense of a colonial state, the people had their ways of naming, understanding, resolving disputes, preventing disputes. But then the colonial imposition sort of, in the first processes, erased it. And then after the First World War, when the colonial administration embraced what they call indirect rule, started to rehabilitate part of it and bring it back. But the problem is that the way they are bringing it back was in a hierarchy model, where they're saying, these Africans have been living a particular life, and they are not taking up our way of life fast enough, so as they evolve, we'll allow them to do their things. Then if they evolve fully, then they'll embrace our things. Okay. And unfortunately, after independence, the same model was adopted in our legal infrastructure, where what was called customary law was sort of designed as a placeholder, that before you adopt the state formalist law and state judicial system, we allow you to use your ways. So that is the history. However, our new constitution, promulgated in 2010, changed that framework completely. Because it appreciates that first, the judicial authority comes from the people, meaning that from the very essence of forming human society, people have a way of understanding, resolving disputes, and pursuing justice. Okay. And then the people donate it. So people donate judicial power to judiciary, just the way they donate executive power to the presidency and the executive. They donate legislating power to the legislature. Okay. So that's the beginning, that people have the capacity and the power, they donate it. Yeah. Now in practice, therefore, today, when we talk about alternative justice system, we mean
Dr. Steve, I want you to just hold that thought just for a minute. Now, as you take us deeper into now what the alternative justice systems are, but let's get back to our topic of the day, and you're talking about alternative justice systems. And my guest, Dr. Akoth, Steve Akoth, was actually trying to explain how now, from, can I say, Dr. Akoth, that's what you said, from the traditional way of doing things, and how now we've actually embedded, can I say, the alternative justice systems into our new constitution.
Indeed.
Yes.
Indeed. And so the case is that, like you've really rightly put it, so therefore, in the new constitution, the question becomes, what do we mean by traditional? And that's a very important point to ponder on, because in the colonial idea of tradition, tradition was treated as this bad thing, old thing, uncivilized, or yet to become modern. But our constitution treats tradition as the way people do things in their everyday life, and therefore it gives us a criteria on how to choose which tradition is acceptable within our dispensation and which one is not. And so the criteria is in Article 10 of the Constitution, those that advance values of dignity, human rights, inclusiveness, sustainability, and other parts, like if you go to Article 27, must be those that do not promote discrimination and so on. And then tradition also in our constitution is not just about language, cultural tradition. It's also tradition of various social formations. For example, in this country, matatu industry have got a tradition. If you go to a school, you have the school students' council. There's a tradition there. You know, if you go to church, if you go to a mosque, if you go among the youth, they have a tradition. So this tradition that we're talking about is both from language culture and social formation culture. And all of them are encouraged to use various strategies, so long as they're aligned to the Constitution, to promote justice and to resolve disputes when they arise. Okay. That is really the meaning of AJS.
Okay. And like you've rightly put it, I mean, in our traditional way of life, there were conflicts, you know, before, and they had a way of resolving them. And you've rightly explained that, you know, the Constitution recognizes some of those, you know, traditions and ways of resolving conflict. But before we get into the nitty-gritty of, you know, what some of these alternative justice systems are, let me bring in Honorable Rehema Masha. She's the Assistant Deputy Registrar, Alternative Justice System. So just to set the, you know, the ball rolling for us, what does your office really deal with?
All right, thank you. At the Secretariat, which currently supports the National Steering Committee on implementation of alternative justice systems, we are what I would like to call the boots on the ground. Okay, we are the ones who are now currently rolling out these systems and operationalizing Article 159(2)(c), as Dr. Ray had mentioned, which then talks about the use of alternative justice systems in the administration of justice. So that's what we do at the Secretariat. Just to add on to what Dr. Ray had mentioned about what AJS is, I would like to say that AJS really is just those community-based or non-state mechanisms for dispute resolution. And as Dr. Ray rightly put it, it's all about going back to our customs, our traditions, and there's a distinction, as he put it, between customs and traditions, going back to our social structure, our moral beliefs, and our value system. In accessing justice. Okay. Yeah.
There's something I've heard is called alternative dispute resolution. Is that part of the alternative justice system, Dr. Akoth, or is it an do you use them alternate or can you use them, you know, alternatively, if I may put it that way? Is it the same thing when you say alternative dispute resolution and alternative justice systems? Thank you.
And now you've asked a question like a university professor. This is a very good question, very important question. Look, and I really want to create a distinction. So, what happens is that we have what we call, and the Honorable Chief Justice has named it as such, multiple doors of justice. So you have many doors you can use to access justice in Kenya, and our Constitution provides for it. Article 159(2)(c), as my sister, Honorable Rehema, has said. Now, there's something there, which is you can access justice by going to the state-based courts. That is one system. You can also access justice by going to what we call largely traditional avenues. That's another system. So the first distinction is that we have, at least for purposes of illustration, two systems. One system which is based on the state formalist laws, another one based on norms, custom, traditions that people have developed for themselves over time. So the first distinction between the two is that one is a system, AJS is a system. Now, ADR, alternative dispute resolution, is a method. Mediation is a method. Arbitration is a method. Reconciliation is a method. Conciliation is a method. So you see, you have systems, then you have methods.
The methods.
So this method, like ADR, you can use them both within the spectrum of a state-based court You can use them also within the spectrum of AJS. But the advantage of these methods is that they also give us the avenue for bridging, because these systems do not operate in parallel. They operate in a continuum.
Okay.
You know, it's like a relay, You know, the first person takes a baton, gives the next person. But you know, the last person in the relay does not give the baton to anybody, finishes the race. So you can have a system where a matter begins in court. The court says, this thing has elements which cannot be understood in our system here. Can you take it to AJS? Then AJS, once they decide or have a recommendation of the matter, they bring it back or they conclude it. There can also be an instance where either of the system are seized of a matter and they move it to conclusion in their own motion without bringing them back to each other.
Okay.
But these methods are very useful, that they help us also to interface at the various systems.
So I think you've just explained how the AJS and now the alternative dispute resolution differs from our modern way of, can I say courts, let me call it modern way of conflict resolutions and all that when it comes to arbitration or you know, mediation and all that. And so what kind of cases, can I put it that way, Dr. Akoth, even as I'm going to talk to Marsha on how then the courts decide what goes to or what cases can be handled using AJS. But what kind of cases then does the alternative justice system, you know, deal with there?
Thank you. Yeah. So we have this question of the jurisdiction of alternative justice systems. And in the old days, again, people used to put like a ruler and say, these cases, big cases, go to court. Small cases can go to the alternative methods. Or others would say criminal cases would go to court, state-based courts. The other civil cases would go to alternative forums. So we have moved beyond that. And the method we're using is first to say that almost all type of cases, I said almost, can go to AJS. Apart from where the Constitution says that this matter can only be adjudicated by the state-based courts. For example, presidential disputes can only be adjudicated by the state-based courts, more specifically, the Supreme Court. Then, there is also the question of how do people find themselves in AJS forums? People must choose. So the first thing is people must choose and say, I consent to go there. Once you consent to go there, then it can decide your matter. Then that raises a question. Is everybody able to consent? A child cannot consent. That means that when a child is in conflict with the law, then they have to go to the default forum, which is the state-based court. A child who is defiled, for example, cannot decide to go to AJS. No, she's not in the age of decision, according to our idea of agency in terms of a legal framework, but also in terms of age and growth. But even more important, how about if somebody threatens you to consent? Then that is also not consent. This consent must be objective, where you are doing it in your own volition, knowing clearly what you are getting into, and accepting that this is your choice. We have summarized this into what we call a positive test, a negative test. And we always start with a positive test. We ask a question, do these parties agree to go there? They must agree without being compelled. If the answer is yes, they will go to the negative test. We ask, is there a constitutional provision that says that this matter is best handled through the courts of law? If there is such a provision, then this matter cannot proceed in AJS forum. Or is there a statutory provision that says this kind of a matter is best considered in state-based courts? If there's such a provision, no. Or sometimes a matter can be such that AJS can deal with it, but it's of such public interest, and the decision made out of it would have such implication on broader access to justice. then that must go to state-based courts. But most important is that you see that we're moving away from that imagination that small cases, big cases, criminal cases versus civil cases. And we have another test which then takes into account beyond those two. But finally, recently, in our conversation, we have had another idea of something called hybrid. Take, for example, matters of children, especially children who find themselves in need of protection by the law. Orphans. When a child is an orphan, a matter which could be part of the whole continuum of succession. Maybe they are being evicted. But the so-called wazee can decide how to offer custody to this child as we wait to conclude, for example, a matter of succession. In such cases, we argue that it is best that, first of all, that matter or the company that goes to AJS be done, but with the supervision of the court, because a child requires what we call a protective forum, and the court is the best protective forum. So you don't decide by yourself to take it to AJS, because this child requires particular protection. This matter should first be placed before a court of law, following the appropriate procedures and following the appropriate prayers, and then the court will decide that to ensure the best interest of this child, as we determine the bigger question, could be, I'm just using succession as an example, let the following happen. Let them get custody from a neighbor or from the church or from a foster father or mother, something of that sort. So there we require this protective supervision, and we're calling this some sort of a hybrid.
Hybrid. Okay. So Honorable Masha, just as Dr. Akoth has explained in terms of the types of cases that can end up in alternative justice systems or in the, can I say, state-based courts. In your experience working, and within the AJS, what are the cases, can I say, that you see reported most of the time? I know we have issues of land in this country, historical, and all that, but what are some of the cases that you see people come with when it comes to AJS?
All right, that's a good question. But before I answer that, I think it's important for our viewers to appreciate the typologies that we have under alternative justice systems, which Dr. has spoken to. So first of all, we have what we call the autonomous typology. This is where dispute resolution occurs completely independent of the courts, okay? It's the everyday Nyumba Kumi sittings that we have. It's the everyday resolution of disputes at the chief's office that's ongoing, without any state intervention. Then we have what we call the third-party typology. The third-party typology is where we have both state and non-state actors coming in to be able to help in dispute resolution. Okay, so we have, for instance, we have religious organizations, and then now finally we have what we call the court-annexed typology. Now, under the court-annexed typology, so we have people who come in with disputes, right? And as Dr. has rightly put it, there is a screening tool that we use to measure whether a matter is ripe for dispute resolution under the alternative justice systems, and that is the positive test and the negative test, right? And once that screening has been done, then a matter can be referred to alternative justice systems. Just to mention that we do have working groups across the country that are working with our courts in various stations to be able to dispense justice through the alternative justice systems. So the types of cases that we get mostly are land is a key, is one of those issues that is very prevalent, especially succession matters. We also get some criminal matters, And really, the benefit of alternative justice systems is we get some of the remedies that you would not be able to get from the court, the formal court system, right? Like restoration, like mending of that social fabric, right? And so we get some criminal matters. We deal with some criminal matters, those that for instance, do not have policy that specifically prohibit the use of alternative justice systems, and also a wide array of civil matters as well. Yeah.
Okay. Dr. Okoth, so just as Honorable Masha has mentioned that, you know, land succession, issues of, you know, children and all that can actually be dealt with under AJS. But sometimes the concern will be, how binding are these, you know, decisions? So I decide for whatever reason I'm gonna, you know, go the AJS way, and we sit down and we agree whether the chief is there and the family members and all that. But how binding are they, such that years to come you do not find people going back into the same issues? Yeah.
Thank you. Yeah, that's really an important query as well. Now, remember, people go to AJS system as a matter of choice in their own volition. And I'll give you an example. Take, for example, during the performance of customary marriage. People go and exchange gifts.
Yeah.
And I hope me and you know that we've seen that people consider it fairly binding. And we saw evidence from some community in Machakos, for example, where people record these matters. I must say I was personally shocked one time when I went to visit my in-laws. I'd gone there about a decade earlier, and when we opened conversation on whether I had anything due in terms of my bride price exchange, a book was produced. I never knew a book existed.
Yeah.
So people record these matters, and they are binding. But from what framework? Again, this is important, from the framework of obedience. Part of the mistake we make is we assume that the fact that the state has a police to enforce, that every agreement requires a force-based enforcement. That is not true. In systems where people choose, obedience sometimes is a default. But then, back to then, how the policy deals with the question of ensuring that what is discussed within AJS forums has got, you know, sustenance of a justice journey, is that we have developed what we call doctrines of interaction, which is to say, when a matter is decided or recommended by an AJS forum, and then one of the parties go to court, or this question lands in court again, what happens to the decision or recommendation that was made in the AJS forum? And we have said that the AJS forums, first of all, the court can't avoid those decisions. They can't say, Apana, me, I don't recognize this. No, they can't avoid them.
Thank you for staying with us. You're watching the News Check, where today we're talking about alternative justice systems. And in studio, I've been with Dr. Steve Okoth. He is the Vice Chair, National Steering Committee on Implementation of Alternative Justice Systems, and Honorable Rehema Masha. She's the Assistant Deputy Registrar, Alternative Justice Systems. And we continue with the conversation, as we've already laid the ground that we know that conflicts will always be part and parcel of the, you know, human race. But are there alternatives, you know, away from the state-based courts, which sometimes can be expensive and time-consuming? But we'll be getting to the benefits of the alternative justice systems in a moment. But let me give Dr. Steve Okoth the chance to continue his line of thought. We're talking about, you know, how binding is alternative justice systems, you know, if, and especially for vulnerable groups, you know, women, orphans, children, when they decide that they want to go that direction, how binding are these, you know, agreements?
Yeah, thank you. Yeah, so as we are saying, so the courts have no option of avoiding. You cannot say that we don't recognize, or this is not within our realm of consideration. They can't avoid. The courts can also not say, look, we'll only look at it from the optics of formalist state law. That is sort of, say, use what we call a monoist system. Say, no, there exists no other law apart from our law. No, the state must, the state-based court must look at the matters when they come to them as those that emerge from systems that have got legitimate crafting, legitimate procedures and so on.
Okay.
But then, so I've said what the state-based court can't do. What can they do? They can consider the matters coming from the AJS forums either as evidence, so that you say, okay, you have made this petition, and you are also saying that these have been the conversations and perhaps decisions, or conclusions, or agreements that subsisted before we came here. So then it is used as evidence, and you say, this is normally we call it a facilitative function. A facilitative function.
Okay.
There is also an option of the state-based court saying, look, we will defer to it, we'll defer to what you've done, but we'll look at your determination, your decision, your recommendation to see whether it is proportional and whether you have also followed the procedure, taking into account the notions and practice of natural justice. Okay? And finally, sometimes the state may say, look, this looks very good, so we will just accept it and implement it. You know, that happens a lot in arbitration. Okay. But it also happens a lot in mediation. So back to the question is, the bindingness of decisions in AJS mechanisms is often inborn from the notion of obedience. We chose to go there, we'll obey what happens there. But in the eventuality that these decisions or recommendations go to the state-based courts, then I've outlined how the state-based courts are invited to interact with them, often within the language, within the logic of promoting AJS rather than demeaning or considering AJS as a subordinate.
Okay. Thank you so much, Dr. Steve, for that elaborate explanation. So, Honorable Masha, if I have a land dispute, for instance, or any other domestic, dispute, my neighbor or a family member, and I'm listening right now, and I'm like, okay, the cost of getting a lawyer, the time that it takes to resolve some of these court cases can be quite discouraging for many people, and they will decide, like, you know what, let me forget about this whole thing, let them have it. Or it might lead to, can I say, a lifelong conflict within families or neighbors for that matter. But if somebody's listening right now and they're like, well, I think I can actually try this. What is the process? I have a dispute of some sort and I'm thinking like this could be the alternative. Even as we talk about the costs, benefits of it. But what is the process of someone who would want to go this direction?
All right. Thank you for that question. I'll speak first from the perspective of being, part of the judiciary. So, first of all, the courts have a duty, as per Article 159(2)(c), to promote the use of alternative justice systems, right? So, a justice seeker can approach the court and inform the court that they would like this dispute to be resolved via alternative justice systems. And the court will use the referral pathways to be able to direct that matter to alternative justice systems. We have working groups spread across the country that are annexed to the court, and these individuals are able to sit in panels and discuss these matters, and in that manner they're able to resolve the disputes. And again, as Dr. had said, the court then plays a supervisory role, right, to ensure that the outcomes of these processes are in line with constitutional minimums. So that's the first way you can approach the court. Secondly, like we had mentioned earlier, we have those third-party forums, right? So that we are working with other organizations, both state and non-state, to be able to resolve disputes. So you can, depending on the type of dispute, we have the Office of the ODPP, we have the Probation Services Office, we have children officers on board. So these are all actors that you can approach, including even the Ngao, right, to be able to have your dispute resolved. So it can be as easy as walking to your chief, right? And we are in touch with these actors, and we are taking in the data, and we are also ensuring that the outcomes of those sittings are in line with human rights imperatives. Yeah.
Okay, and you know, just as you've mentioned, I'm thinking, is it free? Because, you know, we talked about the cost of it, getting a lawyer and go through the normal court processes. What is the cost, or is it free? Yes,
I would say largely it's free, right? The only cost, and the cost that is incurred on the part of those who are facilitating the process, right? So judiciary first incurs a cost, but they have a duty, right, to promote, and so that means that they have a duty again to allocate resources, right? So the cost that is incurred is on the part of the actors. So the panelists could incur a cost maybe to convene that sitting, right? And we are working towards ensuring that these sittings are convened in a dignified manner, right? So we want to move away from the issue of kangaroo courts and sitting under trees and give it a more dignified approach. So we are trying to establish ukumbis across the country where people can come in and have their disputes resolved in a more dignified manner. So really the cost is really just on our side as the facilitators, but largely the justice seeker incurs a very minimal cost, maybe just transportation to the venue. Yeah. Okay, so this is a decentralized service, which means you can get it right at your home, rural areas, and all that. Yes, that's, we are working towards realizing full decentralization to the 47 counties. So far we've launched about 13 registries and fully equipped ukumbis. We have about 39 in the pipeline. But ideally we want to see a system where you can walk to your nearest court station and get those services. Yeah, so it's decentralized, yes.
So, Dr. Akoth, I mean, definitely there was a reason as to why alternative justice system was then embedded into the, the constitution, and now, used in tandem, can I put it, with the state, state-based courts. There were benefits to it, and that is, if I might just think one off my head, is, the benefits being the relationships that were, can I say, can be destroyed because of some of these conflicts. For instance, with its land, you find that a family is disputing about a certain property, then someone dies, then the next generation keeps taking it and all that. And so there's an enmity that actually brews because of that. So maybe you could also take us through some of the benefits of alternative justice systems, other than just the issue of restoring those relationships and how that happens. And we've all known that there's the issue of case backlogs in the courts. So maybe you could talk to us about the success rate of some of these alternative justice systems, and how they've benefited in terms of restoring relationships, and also helping in terms of case backlogs in the courts.
Thank you very much. So the first thing is that many people, as you rightly say, normally think that the only benefit of AJS is in terms of saving cost. But did you know that the most important and indeed significant and consequential impact of AJS is that it raises the question of whose justice are we talking about? Yeah. It enables the parties to engage and realize justice the way they see them. And I'll give an illustration. There was a matter where a couple had a quarrel, and unfortunately the man assaulted, or rather, let me say, physically abused the woman. The woman went to the, to the police, and the police arrested the man, and of course, the man was being charged by assault and causing grievance bodily harm, and so the matter went to court for mention, and when the matter came for mention, when the prosecution had spelled out the charges, then the woman who was a complainant raised her hand and said, well, when I went to the police, I didn't want the thing to reach here because the problem of that assault arose because we differed on something else. And the something else that this gentleman does not take bath, he doesn't shower. And so he produces a bad odor.
Yes.
And for that reason, we are unable to live comfortably as a couple. All I want you to tell him is to go and take bath regularly. And then we can live together as a happy couple. You see now, the idea of justice, according to the victim here, is very different from the idea of justice the way the prosecution had framed it. And this may sound mundane, but it is the substantive rationale for many people to choose AJS. Whose justice are we talking about? How does this justice look like? Must this justice be reparative, that is an eye for an eye, or can it be one that restores, restorative justice? And many people want restorative justice. So that is the first important rationale and fairly consequential reason why people take a choice. Then the other thing, as you've rightly said, we must conclude as Kenyans that even if we built a court station in every ward in this country, it is not possible to satisfy people's quest for justice with expansion of state-based courts. Because first of all, we know that people choose to access justice not singularly through these courts. So the second benefit, therefore, is that people want to choose where to get justice. So promoting AJS enables that. Then there's an important thing you've raised about backlog. We also know that the number of judicial officers, the number of judges whom we have will never be proportional to the exact number of matters that are brought before them to adjudicate. So therefore it's important because you know that in terms of statistics, only 17% of disputes end up in courts of law. Yet the largest proportion, over 63% are dealt with outside court. And this 17% is a backlog question. Now imagine if the other 63% would have gone to the state-based courts. It would have completely overwhelmed them. So it will help. It helps to solve the backlog. But remember, it is also about helping people to get justice where they are. And finally, and very important, which was also touched on by Honorable Masha, is that, and this is something that the Chief Justice has really insisted, is we have to move beyond the division between justice seekers on one side and justice providers on another side. Our constitution is one where Kenyans want to be part and parcel of their governance in terms of judicial function, in terms of executive function, and in terms of legislative function. And so AJS becomes an important participatory avenue that enables people to cross the boundary that divides them between the justice seeker on one side and the justice provider on the other side. Yeah, I dare say, now as a scholar, that in fact that divide is a very old idea of a state where people produced a giant who would be the provider for everybody. And the problem people have known is that when you have that giant, the giant can grow so big and can eat you up. So our constitution does not require a giant. It requires movement of justice, which then invites the institutions and agencies of the state and the people to collaborate in expanding access to justice.
Okay. And then, just like you said, the government or the judiciary, for that matter, cannot, can I say, fulfill, you know, when it comes to staffing and everything, so that every Kenyan can access justice from whatever they are. And it's a good thing. We have the elders, we have the chiefs, you know, in our communities and all that. But how do you, are they trained, Honorable Masha, are they trained and, you know, or accredited to the AJS system, such that if anybody approaches them, they can actually, because apart from just the chiefs themselves, can an individual person like me become a mediator, and what are the qualifications and the processes of getting?
Let me start off that before we go to Honorable Masha, because these are very significant policy questions that you've raised there. First of all, you know, Shakespeare invited us to debate this question: what is there in a name? Is an a rose smells the same irrespective of the name you call it? So can we use any name? So we have dealt with this question of naming, and we would rather call them AJS practitioners, so that then you are not caught up in the category of an elder as being a man who is of advanced age and often putting on a monkey skin and walking with a fly whisk and, you know, bending and so on. So AJS practitioner takes into account all interlocutors who are able to take a position of honor and authority in the normative system. If you go to a church, the church elder. If you go to a mosque, there's a, you know, there's an elder there. If you go to a synagogue, there's an elder there. If you go to the border holding point, they call them either stage or shimo. There's somebody who they consider as a person with authority to help them adjudicate. If you go to a market, especially in Kenya, we have these chains of markets, we call them soko mjingas. These are markets where basically people go and just take space and put their wares. Disorder. You rarely hear people are fighting to occupy space in this market. Why? It's because they are systems, they are institutions, they are persons whom they have designated to be sort of their adjudicators, to be able to enable them to resolve matters. These are practitioners. So the right concept to want to put forward is this one of practitioners. Then there is a question of skills. You affirmed a very important point, and I was very happy when you said that what the Constitution does is to recognize. It does not establish. They have been there. But then there is a thing. Does everything go? No. We have Article 159(2)(c) that commands the judiciary to promote AJS. But it is also read together with Article 159(3) ABC that provides conditions to that promotion, to that acceptance. It says must not be practices that violate human rights, must not be those which are considered repugnant. Of course, there's a problem, and we have to creatively understand this notion of repugnancy. We can deal with that another day. And also must be those that definitely does not conflict with any other written law. So to ensure that, the Chief Justice has put together this committee, where I serve as Vice Chair, whose role is to create awareness, sensitize, and educate. So yes, we invest in educating, giving skills to AJS practitioners all over the country. And we do that, as was said by Honorable Masha, through the court user committees. Court user committees are stakeholders who come together to work within the jurisdictions of various court stations or courts in the county to share knowledge and to exchange experiences on how to advance justice. So we work with them to train. And so far we've trained a significant number. For in the last decade, since the unveiling of the policy, we've trained close to 20,000 practitioners in the country. We have also ensured that in each county we support conversations on the question of what is your justice issue. If you go to Kajiado, the land question expressed there is very different from the land question expressed in Turkana. It's land, but the land justice question in Turkana is different from land justice question in Kajiado.
Okay.
If you go to Kisumu, the land question is different from the land question in Mombasa. Yes, all of them have got big water bodies, but it's different. So this idea of inviting people to discuss the justice question is a preamble to training, but also a preamble to outlining what we call a justice action plan. So every county we go to then develops a county AJS action plan that is a blueprint of how to advance their justice journeys, but also how to develop skills to enable them to move together in that with the judiciary. And because the Honorable Marshal normally sits in the Secretariat that does this, I'm sure she has something to add.
Yeah.
Thank you, Dr. So the short answer to your question, Marie, is yes, you and I can be AJS practitioners, just as Dr. has said. And we are moving away from the notion that you have to be an old man or an old woman for you to be able to sit in an AJS panel. You could even possess certain expertise or skills, right, which would be very vital in that particular issue. Yeah? And so that makes you a very suitable candidate to sit in that panel. Do we conduct training? We do, not on technical aspects per se, because we believe in this system retaining, that organic nature, yeah, where the actors are allowed to be able to solve their disputes organically, right? So if you're going to, for instance, use traditional dispute resolution mechanisms, we won't train you on how to do it because you already have your way. The system has always been in existence. But we're going to train you on certain constitutional minimums, certain human rights imperatives, and we're going to train you on the supremacy, for instance, of the Constitution, right? So those are some of the aspects that we take into account. But no, there isn't any technical training or accreditation per se.
Okay.
Yeah.
And still on that note, so how is the feedback from Kenyans, from the communities that you've worked with in as far as the AGS is concerned? Are Kenyans increasingly embracing it, or what's your feedback?
The feedback has been overwhelming. Like we had stated earlier, in a justice survey that was done, I think that was in 2024, about 64% of Kenyans preferred to use alternative justice systems, right? So the uptake is really good, and I want to say that AGS has stood the test of time. It has always been there with us. What we are doing right now, and the Constitution did not invent AGS per se, right? It only served the purpose of entrenching it into a system, right? So what we are doing right now is just to create more awareness, to let people know that we have this system and it is working, and the kind of justice that you get under AJS is not of low quality compared to what you would get in the formal courts, right? In fact, you'd be able to get remedies that probably a formal court cannot give you. Yeah.
Okay, so Dr. Akoth, now looking forward, what reforms and strategies do you think still need to be embedded to ensure that the AJS works seamlessly?
Well, so looking ahead, first of all, based on this great feedback we are getting from Kenyans, is that the Honorable Chief Justice, Martha Koome, has done a very revolutionary work in developing a framework that guides her leadership called STARGE, which is a short phrase of social transformation through access to justice. And the essence of STARGE is to ensure that there is a seamless work between the various doors of justice, so that she is retaining allegiance to Article 48, which talks not about necessarily the centrality being access to courts, but being access to justice. And then Article 22 of the Constitution creates court as a default forum in that enabling of justice. But then Article 159 to see that we've talked about several says, even the courts and tribunals are to remain default. Please, you must promote AJS. So first of all, we have a tidy constitutional architecture which has now been unbundled through STARGE. And more practically, we think that Kenyans are being invited to move away from a culture of taking law into their own hands, as we saw in yesteryears of mob violence. Some people call it mob justice, but it can't be mob justice. It is mob violence. Kenyans are also being told that, look, it is good to exercise your autonomy, it is good to be innovative, but that innovation only survives, only becomes useful when it aligns with the law, when it aligns with the Constitution that we have given to ourselves. And remember, we have always said that every day we implement the Constitution, every day we innovate around it, we are promulgating it. So STARG is inviting us to continuously promulgate this. And then, two other things which are very important is that this approach that you see in STARG and you see in AJS is also about becoming Kenyans. You know, these are always said the difference between just being the people of Kenya and becoming the Kenyan people. So this is, we have to socialize ourselves to be the Kenyan people. What are the Kenyan people? They're the people of justice. They're the people who can talk justice in various languages, yet they understand each other. You can talk justice in many languages, but understand each other. And finally, which is important in that question about ensuring that we have convergences, and that's been said very well, and is also, symbolized in this panel. AJS and what STARG talks about, multiple doors, is not about only the old people. It's not only about men. It's not only about people of certain classes. It is really a way of creating a justice platform that can bring in people from whichever position they come from. Including, some people say erroneously that AJS is mainly used by the poor. No. Me and you know, if you look at, for example, how people coexist in residencies. Many things happen in residencies, especially of people who are well off, who take nuisance very seriously, and they resolve them through AJS. We have even seen matters of, which are matters of sometimes strict liabilities, people involved in car accidents that does not cause fatalities, prefer AJS. People in maritime industry prefer AJS. So we have to remember, it opens doors for everybody from whichever position they come from. And that is why Article 48 is emphatic on equal access to justice for all people. Those words are not just idle words. First of all, everybody accessing it equally. And finally, all people, irrespective of your criteria of diversity.
Okay. You're talking about irrespective of their standing in society and all that. And like you rightfully put it, it's not just for, can I say, the lesser or, a background or anything of that sort. So, Honorable Marsha, I don't know, when in the process of work and all that, so we have marginalized communities, definitely the youth and also, can I say, women. What differences are you seeing? Are you seeing men embracing this more? Are there some hindrances when it comes to these marginalized communities? And if so, what can be done to ensure that those who are marginalized, for that matter, are able to access and even embrace the system?
All right, so indeed there are some challenges, and when it comes to the issue of inclusion, we've witnessed some challenges, maybe, when you look at maybe the northeastern part of Kenya where the participation of women is still wanting. But one of the things that we advocate for, and even we talk about this even in the training and sensitization sessions, is we have to ensure that all groups are included in the process. So women, children, persons living with disabilities, and other minority groups, refugees, you name it. So we always advocate for a gender-balanced panel, for instance. Those are some of the things that we are advocating for. A gender-balanced panel, so that when we have, for instance, 3 panelists sitting, at least one of them is a woman. That's one of the ways of bringing on board these groups. We are also conducting specialized trainings now for these minority groups, right? For instance, the refugees. Just the other day, we did a session with refugee refugee consortium of Kenya, together with Kituo Cha Sheria, and we just wanted to reach out to the refugee community and tell them that AJS is available for you, and it's a great way of having your issues, your justice issues addressed. So what we're continually doing is carrying out sensitization and trainings to be able to get the word out there and to let people know that everybody needs to be included in this conversation, and AJS is not about discrimination in any way.
Okay,
Yeah.
Thank you so much. So, Daktari, there is a conference coming up very soon in as far as the alternative justice system is concerned. But before we get into it, what are some of the learnings? Because I'm sure you're collaborating with other countries, and if I may put it, maybe other African countries. What are you seeing are some of the similarities and even things that you can borrow from the different countries that you've been able to interact with?
Yeah, thank you. Yeah, we collaborate a lot with many other jurisdictions, and we have sometimes been just standing a little bit more because we think we have really done an innovative approach to it. But yes, indeed, we have learned quite a couple of things from South Africa, where apart from the structural design to appreciate other doors of justice, they have been very keen on the philosophy of justice, the notion of Ubuntu, which become very central, and that's a great lesson that we've got. A country like Ghana, where we've realized that, and you'll be shocked that you do know there's a limitation that AJS, what we call AJS here, cannot adjudicate on environmental matters in Ghana. Yet here, as I told you before, our jurisdictional framing is such that we can do it. We also have realized that there's some countries, especially the far edge of Southern Africa, Botswana, Lesotho, where the AJS systems work through a state sort of recognized structure. They have like a dual system.
Yeah.
Like in Lesotho, they have got traditional courts, and they have got the state-based courts, and the traditional court is seen within sort of the linear chain of justice providers, which then, in our view, limits it to some extent. So those are the kind of lessons that we've gathered. But there's something else also that was mentioned by Honorable Masha, which I want to come back to, which is a question of, we've also learned that AJS gives us a new way of governing diversity. Diversity is not new. There are countries where there have been projects globally. This diversity question is a global problem. Sometimes they say, let us move towards assimilation. And they say, everybody be the same. And we've seen this even, especially in the European Union, how to deal with diversity. In the US, used to talk about the notion of America is a melting point. So you come here different, but after you arrive here, we must be American and take particular creeds and orientations. So we think this assimilation approach is wrong. And we have then, through AJS, suggested another way of governing diversity. A way that is democratic, a way that is human rights centered, a way that sees diversity as a resource, not a risk. But to do so, our education approach in AJS has moved away from what you saw in this country before 2010. Before 2010, diverse groups which were considered to be, quote unquote, uniquely different, I say quote unquote because I don't believe in that notion, were isolated. The Ogiek, the Maasai, the Ndorobo, the Samburu were even at the threat of their identity being erased. The Pokot, the Pokomo. And you would see them, they would always been highlighted. If you go to the museum at that time, they'll be highlighted in the museum.
Okay.
And we believe that approach was wrong.
Okay.
What we've done is to create a system where there is a human rights conversation between the life choices and experiences of all diverse groups,
Okay.
with the idea of human rights, the way we have agreed to have it in our constitution. So that instead of saying we'll retain this group as quote-unquote indigenous museum material, you move beyond that. And everybody then has an opportunity to define the Kenya we want, based on the framework of human rights, on the framework of equality, on the framework of human dignity for all. So we discover within the Maasai culture, we discover between the border operation, we discover among the Subaru drivers, so to say, as an association, we discover among the fishing folk, how do your norms of governance align with human rights? And you've seen it also among the private associations. In this country, for example, there was a question one time, I won't mention the name of the club, but there's a golf club whose matter went to court, and the golf club had suggested that here it's only men who can lead and women can't participate in elections. But the court were very clear and said, look, human rights and the principles of our constitution applies to all, in private and in public. So you see, this conversation of building a new Kenya applies in those multiple realms. And yes, the way we practice our standard.
Okay.
Coming to the conference, every year, the Honorable Chief Justice convenes a National Assembly of the AJS movement, bringing actors from all over the country. And we do it largely in universities. Why? Because we believe that this work is not just about expanding access to justice as a practice, but also building a particular set of knowledge that will craft, enable, and advance this idea of justice. So in the year 2026, we'll have it at the Embu University. The dates at 16 to 19. And the Honorable Chief Justice has promised to spread invitation to Chief Justices from other countries, and we are looking forward to a good conversation.
Thank you so much, Dr. Steve Akoth. He is the Vice Chair, National Steering Committee on Implementation of Alternative Justice Systems, and also Honorable Rehema Masha, Assistant Deputy Registrar, Alternative Justice Systems, for coming into the studio and just, enlightening us as far as the alternative justice system is concerned, the benefits of it, and that it is not a lesser process than the, state-based courts. So I'm hoping that whoever's been listening, our viewers, have gained a lot, and that you do not have to fear to seek justice, because there is alternative justice systems which can actually guide you, cost-effective and also restorative, if I may put it, and all that. So thank you so much, gentlemen and lady, for coming into the studio. We hope to hear from you more as you prepare for the conference in June, and hopefully there also Kenyans can actually come and get more information in as far as the alternative justice systems is concerned. So thank you so much.